Hi, everyone. Happy Friday. I know we've got everyone starting to come in now. We're just going to kick off with a couple housekeeping notes. Thank you for joining us for today's program, Paycheck Protection Program 2.0, Lessons Learned So Far and Considerations for Associations. Before we get started, I'm just going to go over a few housekeeping notes to ensure the best experience for everyone. We do have closed captioning available today. This can be turned on and off by selecting the closed caption button on your control panel. We also recommend watching the program today in speaker view. You can do this by selecting view in the upper right-hand corner of your screen and then clicking speaker view. Today's program is being recorded and a recording will be available a few days after the session. The slides will be shared in the chat today and also distributed after the event. Today we have both chat and Q&A available during the program. Please put any content-related questions in the Q&A so our speakers can see them. And if you have any technical issues, please feel free to send me a private message in the chat and I'll do my best to assist you. Thank you again for joining us. We hope you enjoyed today's program. And without further ado, I will pass it off to ASAE's CEO and President, Susan Robertson.
Thank you so much, London, and welcome everybody. We're so pleased that you joined us on this very important topic, and looking at the number of people that we have on our program today attending, it tells us that it's very important to you. But I want to start out by thanking you for your tireless efforts and advocacy so that we cross the finish line and actually prove to Congress that associations, 501c6 organizations are so deserving of the kind of financial relief through the Paycheck Protection Program. It was a great win for our community. And, we're hearing through various programs now of those organizations that are actually receiving their checks now, and it feels awfully good. And that's because it will help associations sustain themselves through this awful pandemic and come out on the other side able to fulfill their missions. And what a great reason for all of us to come together to advocate for that to happen. So we're pleased, and you're going to learn a lot today about how to take advantage of that. So as I mentioned, there's a lot to cover, but one of the things that was an important element of this win was the fact that we were able to expand the lobbying percentage, those thresholds, so that more associations could be included in the program. Now, right now, there's still some uncertainty about how to calculate around those lobbying activities, and that's one of the reasons why we're here, is to demystify that for us and to really be able to take full financial advantage of the programs that are available to us, and we're keeping a sharp eye on that. So we have really a lot to cover about getting the relief that everyone deserves and that is now available to us, and we've convened some experts from our community, our nonprofit community, that are no strangers to you at all. But we're so pleased that they could join us today, because who better to turn to for the what to do than this group of folks. So first, I'm really pleased to welcome Jeff Tenenbaum. Jeff is one of the nation's leading nonprofit attorneys and is also an accomplished author, lecturer, and commentator on nonprofit legal matters. He's on so many programs, I see him all over, and we know what an expert he is. He's sharing with many. As managing partner of the Tenenbaum Law Group, PLLC, in Washington, D.C., Jeff counsels his clients on a broad array of legal issues affecting trade and professional associations, charities, and other nonprofits. So welcome, Jeff. We're so pleased you could join us today. Mike Tryon. Mike is a member of RSM's nonprofit industry practice with over 35 years of experience specializing exclusively in providing financial management and consulting services to nonprofit organizations. Mike regularly advises boards of directors and senior management about issues associated with new or current accounting, audit, and tax standards. He also provides counsel regarding operational efficiencies and financial controls, adequacy of reserve levels, and strategies for minimizing unrelated business income tax. He's counseled us on all of those things, and we're always so grateful. So welcome, Mike. We're delighted that you could join us. I'm also very pleased that some of our own, Mary Kay Cunningham, CAE, Senior Vice President of Public Policy, and Jeff Evans, Associate Director of Public Policy, are also with us today to give you an insider's view on how the congressional COVID relief deal came together, how they crossed the finish line, and the critical role that associations and you as advocates and associations played in making that happen. As I said before, we're so grateful. So Jeff was our lead lobbyist on this issue. He's worked tirelessly to make it happen. So who better to give us that insider's view than Jeff? So I'm pleased to give the floor to him to kick off the session. So Jeff, take it away.
I appreciate that, Susan. And hello, everybody. Thank you so much for joining us today for this critically important webinar. I'm honored to speak with you and to help provide some of this education. And just to reiterate some of the gratitude Susan shared, I just want to thank you from the public policy team and obviously myself for your advocacy, support, and hard work, not just with signing on to our letters, but also to reaching out to your legislators. And also, and perhaps most importantly, I suspect many of you on this call submitted data for us, which is just truly invaluable and is the ammunition we need to make our points. So just very quickly, because I do want to afford the experts as much time as possible, quick history lesson going back to March 2020. Obviously, things changed pretty quickly. And when Congress passed the CARES Act, they created the PPP. Just before the final version was passed, there was a draft version that included ostensibly all nonprofits, which would have included C6s. The final version included a specific definition of the word nonprofit that defined nonprofit as 501c3 and 501c19, which is a veteran service organization. Thrilled those organizations got the relief they needed, but obviously we were left without. And part of the reason for that was a vast and drastic misconception that 501c6s only existed to lobby the government and to influence public policy. Now, that is one component of many associations and the things they do, the apparatus they have constructed and provide. But what we set out to do early on in the spring and in summer last year was to not only re-educate members of Congress and their staff as to, associations don't just lobby, but they do so much more. Very tangible, empirical benefits to society, the economy, building up people within industries, professions, setting standards, the list truly does go on. And so not only throughout 2020 did we try and stress the deserving nature of, we need these relief monies, but by providing those relief monies, not only would you be supporting these associations and 501c6 is bottom lines, you would thereby be supporting again those small businesses, those member companies, things like that, which in their history probably rely on the support from their umbrella association now more than ever. And so I think, and I hope it goes without saying that we worked pretty hard, and this was a very substantial victory for our community by and large. The inclusion where it is now is not as inclusive as we'd like it to be, but it is still far better than where it was before. And not only I've mentioned the getting the relief money, helping to re-educate members of Congress as to our true function and a benefit to society, but also, God forbid, if something like this happens again, and some new program, whether it's a continuation of the PPP or some new thing, we won't, hopefully, I believe, we won't have to play as much catch up next time, because by including C6s in the PPP now, albeit less than what we want, Congress has formally recognized that we are deserving. So I think that's critically important on a future perspective. Now, all of that is to say, one, we're super pleased that those monies are now at hand. But I do want to make a couple of shameless plugs on behalf of ASAE. Now, this was truly a community-wide effort. ASAE played its part, but it was a big part. And anybody who knows me on this call, I hope you know me well enough to know that I might be guilty of a humble brag every now and then, but I try and keep it relatively modest, although that's an immodest thing to say. But I do think that now is the right time to declare the role that ASAE played in this victory. And, you know, you guys put wind behind our backs with signing on to the letters, providing us with data. But as Susan mentioned, you know, that increase of lobbying activities from 10% to 15%, you know, we were there, and we were a big part of that, and worked very hard to accomplish, you know, that 50% increase, and that's a lot of organizations. So, you know, this webinar is open to everyone, not just members. And so for those non-members on the call, I would respectfully urge you to consider ASAE membership, because from the policy perspective, you know, what we do, this PPP issue is a quintessential example of a broad-based issue that impacts all associations, irrespective of specific missions. So, you know, to keep the community going. So from a policy perspective, we support your flanks and watch your back so you can focus on the issues that are hyper relevant to your association, your industry, your profession. And we can cover, you know, all of those, you know, more broad issue areas. And that is to say nothing of the manifold and very significant benefits ASAE provides beyond public policy. London and her team with events are absolutely spectacular. Our education is robust. The CAE, you know, everybody knows how important that is in our world. And just last, to wrap up, beyond membership, we do also have a Power of A advocacy fund. And, you know, I think we've accomplished quite a bit in the recent past for not only ASAE, but the community as a whole. And we have done so with finite resources. And so just imagine what we can do with a little bit more wiggle room. So I invite you respectfully, of course, to help us get there and continue to progress for our community. So with that, again, really appreciate everybody's time today. Hope you learned a thing or two. I know that you will. And I'll hand it back to Susan or Mary Kate if you wanted to say a word or two. Thank you.
Thank you so much, Jeff. I think we're going to go straight to the practitioners, and we'll give it to Jeff Tenenbaum right now.
Thank you, Mary Kate. And good afternoon, everyone, or good morning to those of you on the West Coast. Welcome to our program today. We have a lot of material to cover in a relatively short period of time. And first off, let me share my screen here so we can get into our PowerPoint. Why is this not letting me do this? Here we go. Okay. Get this into slideshow mode. Okay, here we go. So Mike and I have a lot of material to cover in a very short time. First off, though, let me say kudos to ASAE and particularly its public policy team for really a terrific advocacy job on this. I'm not going to repeat anything that they said. I just want to congratulate them. I worked kind of closely with them behind the scenes, was incredibly impressed with the effort, and obviously very pleased with the result. And if you notice, as you will see as we get into this, of all the different categories of nonprofit tax-exempt organizations out there, 501c3s were included in round one of PPP, but the only category that was added in round two were 501c6 organizations. It's really quite an accomplishment, and they deserve a lot of praise for that. And all of you, I know there were so many of you involved in the grassroots efforts. So this is what we are going to try to cover here today. I know we have 1,000 of our closest friends here on the program. Many of you are close friends of mine. Some of you I don't know, but I'm glad you're here today. We are going to try to deal with all your questions. We got a lot of questions in advance. We already have questions coming in right now, and we're going to get hundreds during the course of the call. Poor Mary Kate is going to have to field all of those and sort through them and pose them to us. We are generally speaking going to leave the questions to the end, but we're going to try to power through this so that we have plenty of time to get to those questions. As Susan alluded to, I have done a few webinars on this topic already, and based on those, a lot of times the questions that come up are questions that we are going to answer during the course of our program. And I am so grateful to have Mike Tryon on this with me, because the last few that I've done have been largely solo or with a banker, but I never had a CPA on with me. And Mike is one of the best CPAs that I have ever known and worked with. I've known Mike since I got into this world when I was working at ASAE, when I was going to law school at night. And we've had a close relationship ever since. He knows these issues extremely well. And I'm very glad that he's going to be able to deal with some of the accounting aspects of this that are, for those of you who know me, math is not one of my strong suits. So I'm very happy to have Mike on this with me today. These are the issues that we're going to cover. We're going to focus primarily on the PPP, the Paycheck Protection Program, what I've called kind of PPP 2.0, kind of this new iteration of it. It's particularly focused on the expansion of 501c6 entities. We're going to focus a lot on eligibility for the different categories of PPP loans, as well as loan forgiveness requirements. And then at the end, we're going to talk very briefly about the expansion of the economic injury disaster loan program. Mike is going to focus on what is a potentially very beneficial continuation of the employee retention tax credit program and an expansion of it in some particularly notable ways. And then I'll speak for a minute to some changes to the charitable tax deductibility rules. But we're going to focus primarily on PPP. So as most of you know, this all came about in a law, very creatively entitled law called the Consolidated Appropriations Act, 2021, a very large $900 billion economic stimulus package that was signed into law by then President Trump on December 27th of last year. Among the other provisions in that law, it included what's called the Economic Aid to Hard-Hit Small Businesses, Nonprofits, and Venues Act. That is the act that contains the reauthorization of lending under the Federal Paycheck Protection Program. It was a successor to the CARES Act PPP program, or what I call PPP 1.0. There was $284.5 billion set aside for this program, with $35 billion of that set aside for first-time borrowers, which would include most 501c6 organizations. And I say most because there were a handful of 501c6 organizations that actually did essentially mistakenly get approved for PPP loans last year. And we actually had an interesting question in the chat that I'll deal with later about that. So $35 billion is set aside for first-time borrowers, but it doesn't mean that it's only $35 billion for first-time borrowers. That whole $284.5 billion pool, with the exception of these set-asides, is available to anyone. But this is important. It's a first-come, first-served program. So you want to apply early. Presumably, most of you on this call, this webinar, have not applied yet, or are considering, or going through the process right now. But you want to apply sooner rather than later, because the money is likely, I suspect, going to run out like it did in the first round. And it may or may not be replenished with additional funds. You all know how things work here in DC and in Congress these days. Nothing is guaranteed, even though this particular program is one of the few kind of bipartisan supported, least controversial pieces of legislation that I've seen in recent years. It's quite surprising in that regard, or impressive in that regard. But that these things are always wrapped up into much bigger issues that are much more politically charged, as the public policy team knows. So there's no guarantee there will be more funding. These loans are obtained through U.S. Small Business Administration, what I'll call the SBA. SBA approved lenders. They are not direct loans through the SBA like the economic injury disaster loans. But you go through a private lender. Many associations are going through their own bank, assuming their bank is participating in the program, which most are. But you go through your bank. The most notable, and the reason why ASAE was pushing so hard to get C6s included in the PPP program, is that the loans are fully or sometimes partially forgivable if certain conditions are met. And obviously most associations are going to try to make sure the loans are fully forgivable. So it turns it into a grant, which can be quite significant, especially if you don't have to pay it back. But there are some aspects of this. By the way, I am the worst PowerPoint creator in history. I do everything you're not supposed to do. I throw way too much text in there. I have no graphics. I have no funny little things, where the text pops up in stages. I don't know how to do any of that. I just put it all in there. You're going to have a copy of this, so hopefully it'll be a good reference for you. But I apologize. Some of the upcoming slides are going to have so much text in there, your head is going to explode. But my apologies. It's just not one of my strong suits. So some key changes for 2021 PPP program. First off, borrowers can set a covered period of the loan which is essentially the end date, anywhere between 8 and 24 weeks after the loan disbursement date. And what that means is that the funds that you receive under the loan have to be spent on eligible expenses during the covered period, at least if you want to get loan forgiveness. And obviously, you're all going to want to get loan forgiveness. Mike and I were talking about this earlier. There may be some instances where you can or don't want to spend them during the covered period, or you can or don't want to spend them on eligible expenses. That's not going to generally be the case, because you want to get at maximum, 100% forgiveness if at all possible. So you pick that 8 to 24 week period, anywhere in between, and you have to spend it on eligible expenses during that period. And we're going to drill down, what are those eligible expenses? And then I'll also talk about later some strategies for why you might want to have a shorter or a longer period, covered period, that you select. Borrowers that reduce wage or employment levels, so total payroll or total number of employees during the covered period, can lose some or all of your loan forgiveness unless one of the safe harbors excludes those reductions in loan forgiveness. And I'll talk about those later. PPP loans can be used to cover additional expenses beyond what was allowable in last year's program. And I'm not gonna actually talk about the details here, because we're gonna talk about it in upcoming slides. This is just kind of a summary of them, but notably there are quite a few additional expenses that should be very helpful to be able to spend the loans on. There was some complaints last time around that the categories of eligible expenses were too small. That has definitely been expanded, but this is an important element of the loan forgiveness portion, which is that 60% of the loan proceeds have to be used on payroll costs. Payroll costs, very broadly defined: wages, employer paid payroll taxes, paid leave, health insurance premiums, retirement plan contributions, and group life, disability, dental, and vision insurance. Those things in italics are new additions this year. So if you want to get full loan forgiveness, 60% has to be used on those things, and then up to 40% can be used on the other eligible expenses. As you all know, PPP eligibility has been expanded to include most, but not all, C6 organizations. I will talk about that. C3s are still eligible, along with C19s, the veterans organizations. If they got a loan last year, they're going to be eligible for what I'll explain in a second, which is a second draw loan. More flexibility provided for seasonal employees, not really an issue for associations. Additional funding is available for organizations that return their original amount or did not receive the full amount for which they qualified. Here we'd be talking about C3s primarily. And then this is really important. So this new law in 2.0 introduces this concept of first draw loans and second draw loans. So first draw loans are defined as both PPP loans that were received under the CARES Act last year, as well as PPP loans received by first-time borrowers this year. So you focus a lot on this, because we've been getting a lot of questions. I've been getting even our questions in advance of this program. There seems to be some confusion about this. So if you never got a loan before, it's going to be a first draw loan. So for the vast majority of C6s, your loans are going to be first draw loans. You want to focus on the requirements, the criteria for first draw loans. For second draw loans, this really only applies in the nonprofit world to 501c3 organizations who got a loan last year and now are looking for a second bite at the apple, which they are very much eligible for if they otherwise meet the requirements. We did have a question about whether if a C6 mistakenly got a first draw loan last year, if they wanted to apply again, now that C6s are eligible, could they apply, what would they apply for? Would they apply for a first draw loan, a second draw loan? Frankly, I don't know the answer to that. I would be guessing, my best guess is that if I was advising, I'd probably say I certainly wouldn't apply for a first draw loan, because you already got a loan under the program. I would apply for a second draw loan, but you may get some resistance. And one of the things that I've seen so far is that despite how the law is written, and there's been a lot of guidance already put out by SBA, which I'll talk about later, it doesn't always work like clockwork. It never does in these situations, but particularly when you have all of this administered by hundreds or thousands, actually, of private banks that are the ones administering this, you're not going to get uniform administration of the program. So you're going to get banks that push back on certain things as they don't get it, or it's unusual, or they don't know how to deal with it. And that's what's going to make this difficult. So while we're going to try to give you as much guidance today as we can, there's a lot of things that we just don't know answers to, and you're going to get some frustrations and road bumps when you work with your banks on some of these things. The requirements for first and second draw loans are largely the same, except there's one notable requirement about the core eligibility standard for second draw loan versus first draw loan. Basically, it's a tighter standard, an additional standard that's been imposed for second draw loans, which we're going to talk about. But then the other big difference is that the basic construct here for the loan amount that you can qualify for is it's the lesser of 2.5 times your average monthly payroll costs, and I will talk about what that means, or for first draw loans, a $10 million cap, or for second draw loans, a $2 million cap. So it's going to be the lesser of those 2.5 times your average monthly payroll costs, or either 10 or $2 million, depending if it's first or second draw. Unless you're a very large association, you're not going to be dealing with that upper cap. You're going to be dealing with the 2.5 times your average monthly payroll costs. Okay, the timeline, the loans were opened on January 11th for community financial institutions exclusively allowed to make loans, and then it opened to all participating lenders, or I think not all, but most participating lenders. Those really large lenders, I think, had a later date, but effectively opened on January 18th and will remain open until March 31st. That's really important, this last bullet point. After March 31st of this year, you cannot apply for a PPP loan under this 2.0 program. So there's a very limited window. And like I said, the money may run out. It may not. But if it does, you certainly want to apply sooner rather than later. Once it's gone, it's gone. Mike.
Hey, Jeff, just a quick update right here, just to give everyone a sense. So as of Tuesday close of business, SBA had approved 400,580 applications for a total of $35 billion. So the money's moving quickly at the end of the day. Just an interesting side point, locally, there have been 13,844 within Virginia, DC, and Maryland. And that's a little over almost 1.5 billion. So the money's moving. That's the latest as of Tuesday close of business.
Thank you. That's helpful, Mike. See, you're always better with the numbers than I am. Here we go. Okay, so sorry for the small text and dense. Actually, this is a slide I'm not really going to talk about much. This talks about, these are all of the different types of entities that are eligible for first draw loans. Of course, you see in the fourth bullet point, 501c6 organizations, and then a bunch of others that are eligible as well. But in the interest of time, we're going to focus on the things that are most applicable. So you might have seen, if you're a fast reader, on the last slide, it talked about one of the requirements for first draw loans is that you have 500 or fewer full and part-time employees. I've had a lot of questions about this. Does full and part-time employees mean like FTEs? And no, every employee is counted separately, whether they are full or part-time. So the general requirement for applicants for first draw loans is 500 or fewer full and part-time employees. But for C6 organizations, there's this sub-limit of 300. So again, the vast majority of associations don't have over 300 full and part-time employees, but some do, and those would not be eligible if you're a C6. You happen to be a C3 and you are a first draw applicant, you didn't borrow last year for some reason, or you didn't qualify, the requirement would be 500 or fewer. So for C6 organizations, because of that concern that Jeff Evans referred to on the Hill about C6s being identified just as lobbying organizations, and you wouldn't want to subsidize lobbying organizations, the compromise was to build this construct, these kind of subcategory of restrictions on C6 organizations. And like Jeff said, the original restrictions were even more restrictive and would have excluded a lot more associations. Thankfully, this is where it ended up. And these are the restrictions. So 300 or fewer full and part-time employees. Secondly, the second bullet point has kind of 3 subparts to it. And if you don't meet any of these 3, you're not going to qualify. So one is that you don't get more than 15% of your receipts from lobbying. I'll talk about that in a second. Second is that lobbying activities do not comprise more than 15% of your overall activities. That's the second one. And third, that your overall lobbying activities do not cost more than $1 million in total during the most recent tax year that ended prior to February 15th of last year. And then the final requirement is that you are not organized for the purpose of promoting or participating in a political campaign. And most C6s, actually really no C6 should technically fit that bill, because by definition, you have to spend less than 50% of your activities and your money on political campaign activities to qualify. So let's
That's
focus.
one question. We got some questions about PACs. Can you just clarify, having a PAC is not related to this? You could still qualify for the PPP.
Yes, having a PAC is not disqualifying. A PAC is actually a separate legal entity exempt under Section 527 of the tax code. It's a separate legal entity. So what happens there is not attributable here, and having a PAC does not at all disqualify you under that last bullet point or anything else. But the one thing I will say, and this gets a little bit nerdy in terms of tax law stuff, which Mike loves when I talk tax code sections. Under this 162E section of the tax code that's referred to in that bullet point below, that's the lobbying tax law, the law that was enacted back in 1993 when I worked at ASAE, and Mike's partner Charlie Tate and I did a bunch of the analysis and speaking and writing on that law. That law, which defines the lobbying for tax purposes for 501c6 organizations primarily, and requires you to capture all your lobbying expenses each year, as many of you know, and then you divide your lobbying expenses by your total dues and other similar income. You get this percentage, which is your non-deductibility percentage, and you tell your members, at least most associations do, that your members are non-deductible as a business expense by that percentage to the extent of your association's lobbying. That definition includes political campaign expenditures incurred by the association. So for instance, if you have a connected PAC, what the FEC calls a connected PAC, which is what most associations have, we're not talking about the PAC's revenue or the PAC's expenses, but the association itself is allowed to pay the cost of administering the PAC and raising funds for the PAC. Those expenses are included as the quote lobbying, it's technically lobbying and political expenses of the association for purposes of that total. And so here, the way it's relevant is this reference to 15% of total activities. That is likely going to be, if it gets defined at all by SBA, and they might not. But right now, my best interpretation, and I think if SBA was to weigh in, they're going to say that means 15% of your lobbying expenses as reported on the Form 990, Schedule C, cannot constitute more than 15% of your total expenditures for the year. And that 15% number, that limit, definition of lobbying activities, would include these things here below. So federal, state, and local legislative lobbying, grassroots lobbying, political campaign expenditures incurred by the association, not by the PAC, but by the association, administration, fundraising for your PAC, other things like that, and certain other expenses too. And then very high level federal executive branch lobbying, like lobbying cabinet secretaries, their immediate deputies, and a number of White House officials. That is your bucket of lobbying expenses that is likely, and what I'm advising clients to calculate to see if you exceed that 15% total. On the issue of 15% of your receipts from lobbying, as most of you know, most associations don't, for instance, have special assessments they assess on their members to fund lobbying. Once in a while you do for a special campaign, but most lobbying is funded from dues and other income, conference registration fees, other things like that, certification revenues and whatnot. And so you don't have specific allocable receipts from lobbying. So one interpretation here would be, well, we just kind of throw that requirement out the window because it's really not relevant. And maybe Congress was trying to really get at a C6 that's really functioning like a lobbying firm. So, and there are kind of some that sort of are like that out there. But the vast majority of associations, that requirement doesn't seem applicable. That being said, it is possible that SBA might come out with some guidance, usually through if last year's passed as prologue, through FAQs. It's possible they'll come out with some FAQs or even in the final rule that says that definition of receipts from lobbying, you have to use that non-deductible percentage of your membership dues for purposes of the lobbying tax law. That's possible. Now, even that being said, from ASAE survey data, I don't believe that most associations have a higher than 15% non-deductibility percentage for their dues, but there are certainly some that do, those that are heavily engaged in lobbying activities. So it's conceivable. Right now, I think there's a good faith argument that you don't have to use that non-deductibility percentage because it's not actually a receipt from lobbying. I think it's a very good faith argument, but we've seen it in many other cases. SBA might come out with some additional guidance on that. All right, we're going to move on. So another issue where it's about as clear as mud. very difficult issue. We got a lot of questions on this in advance. I've been getting a ton of questions on this. This is one where I'm going to explain the issue. I don't want to spend too much time because while I know there are a lot of associations managed by AMCs on the call, the vast majority are not. And so I don't want to spend too much time on this, but I want to explain the issue. So AMCs, association management companies, are for-profit companies that manage associations, and most clients of AMCs are 501c6 associations. Some are C3 associations, but most are C6s. And so while this issue came up last year, and I dealt with it last year, it's really coming to the forefront this year because the vast majority of AMC clients are C6s. So AMCs, as for-profit companies, assuming they meet the number of employee requirements, and I think almost all of them do, except for the really large ones because they don't have more than 500 employees or 300 for second draw loans, they are eligible for PPP loans. And many, if not most AMCs, from what I understand, did qualify for and received PPP loans last year. And this wasn't an issue with their clients because, like I said, most of their clients were C6s and not eligible. Last year, in one of the FAQs, and I have a link to it on the last slide, the SBA had an FAQ that said that if an organization uses a professional employer organization or a similar payroll provider, and these are PEOs are these, in some ways you could make an analogy to an AMC, but in other ways they're different. And a PEO, it's a true joint employer or co-employer situation where an employer uses a PEO, so all the employees are on the PEO's payroll. The PEO processes payroll, it handles all the benefits, all the payroll taxes, everything like that. But the employees are expressly designed to be co-employees of both organizations for legal purposes, for anything from wrongful discharge, discrimination, and everything else. So as contrasted with AMCs, where most contracts that I've always seen and worked on and written for AMCs say that the employees are solely employees of the AMC and they're not joint employees of the client. That being said, there's this reference to in other similar payroll providers, and what the FAQ says that in that situation, the clients of the PEOs and similar payroll providers can qualify. If they otherwise qualify, they can get PPP loans, and that the payroll provider has to provide to the client basically the amount of wages, employee benefits, and payroll taxes that are allocable to that client so that the client can then use it to apply for its own PPP loan. Although they also said that there cannot be double dipping of wages. So if the PEO or the similar payroll provider is providing a certain number of wages and benefits and payroll taxes to the client, it cannot also qualify for a loan using those same dollars, if that makes sense. So then the question is an AMC structurally analogous to a PEO or similar payroll provider? So that same analysis, that same argument could be utilized. The SBA has been completely silent on this. To me, you can make an argument both ways, and you can probably already guess that. I think you can make a good faith argument, have a good faith basis for interpreting the FAQ to make it analogous to a PEO or similar payroll provider. Particularly if it just said PEOs, I don't think you can make this argument. But the fact that it says in similar payroll providers, I think you can make a good faith argument that the AMC clients, the C6 organizations, could qualify. They'd have to get that information from the AMC so they can use it for purposes of the loan application. Are banks going to accept that? I frankly have no idea. We're going to find out pretty shortly because there are some examples I know of some C6 clients of AMCs that have applied for first draw loans, and we're going to see how the banks deal with that. I've not heard anything yet. And we know SBA has said nothing on this, but it's an argument, it's an interpretation. You can also make an argument that, a PEO as a joint employer situation is very different and distinct, and therefore it does not apply to an AMC. And I think reasonable people, reasonable attorneys can differ on this. I'm not advocating what you should do. You have to make your own decision about what you, in good faith, believe to be kind of the proper analysis here. But that's how I see the issue. Just remember what I said earlier, that last bullet point. You can't double dip the wages. So the AMC and the clients of the AMC are going to have an arrangement and understanding. Particularly the AMC has to understand that if its clients are going to utilize those wages, that the AMC can't use those same wages to try to qualify for a PPP loan.
And Jeff, I'll just add in one line. There was a strong effort by AMCs to try to lobby to make this clear that AMCs could apply as long as there wasn't double dipping. And it was just very difficult to get any traction on the Hill. One, because it's so difficult to do anything in Congress now, but there was a perception of the double dipping that Congress has a hard time understanding what associations are in the first place. So AMCs were tough for them. So
that's a great, yeah. And I did a program on this for the AMC Institute last week, and they were saying on there, and I work with a lot of AMCs, that the AMC business model is so hard for people to understand, especially up on the Hill. So anyway, that's my take on that issue. So moving on, first draw loans. This is for most of you, most C6 organizations. Requirements that you did not receive a PPP loan last year, or you now qualify for an increase in the original PPP loan amount because of these additional eligible expenses that you can include. Theoretically, your loan amount could be greater. And so you can actually go back and apply for an increase in your original loan amount. This is primarily for C3s, if you had one last year. Requesting an increase in the original loan does not turn the application into a second draw loan. That's an important point to state. There is the 500 fewer full and part-time employee requirement, but as I said earlier, that is kind of superseded by the 300 or fewer full and part-time employee requirement for C6s. The applicant must have been in operation as of February 15th of last year. And then this last bullet point is very important. This is what is called the necessity test. This is the basic requirement for qualifying for a first draw loan. Borrowers have to certify in good faith and under penalty of perjury that the PPP loan is necessary. And specifically, you have to make a certification that current economic uncertainty makes this loan request necessary to support the ongoing operations of the applicant. It says further, this is from the SBA guidance, borrowers have to make the certification in good faith, taking into account their current business activity and their ability to access other sources of liquidity sufficient to support their ongoing operations in a manner that is not significantly detrimental to the business. So let me unpack this a bit and particularly address some of the questions that I've gotten before and that we got in advance of this program. First off, this is not the same very specific test for adverse economic impact that I'm going to talk about for second draw loans. It's a much kind of looser standard. By the way, this standard also does apply to second draw loan applicants, but there's no metrics here. It's not like your revenues had to go down by a certain percentage. I mean, it is what it is. There's really no further guidance beyond what it says here. I mean, I can tell you generally, if you had some adverse impact, like you lost some members or things like that, but your revenues did not drop, in any, from 2019 to 2020 or 2020 to 2021, I don't know how you could, in good faith, make that certification. But if you had a significant drop in revenues, even for one quarter or over the course of the year, and you've had some significant adverse economic impacts from the pandemic, which most associations have, I think you will be able to make this certification in good faith. Now, that last part talks about access to other sources of liquidity. So I've gotten the question a lot. Does this mean we have to exhaust other loan sources first before doing this? Or does it also mean that if we have reserves, we have to tap into our reserves before we can apply for a loan? We don't have any guidance on this specifically from SBA, at least not that I've seen. But what I can tell you is that we got this question a ton last year from C3 organizations. And there is nothing that we've seen, that I've seen in the application history, in the approval of applications, in the approval of loan forgiveness, that would suggest that you have to either A, exhaust other loan sources or whatnot first, or other sources of capital first before applying, or B, that you have to tap into your reserves before applying for a PPP loan. I've seen no rejection of applications because you didn't tap into reserves. Does that mean anything? Of course it does. When we're trying to interpret, legislation, regulations, you have to look at how agencies are enforcing it here at banks as well as SBA. And so there's nothing I can sit here and tell you that says you have to tap into those other things before you can make the certification in good faith. But can I say with absolute certainty that that's the case? No, but I can tell you that thousands of C3 organizations last year that had reserves applied, received PPP loans, and even some of them have gone through audits on the loan forgiveness side and have come out okay. Mike, do you have any additional thoughts on that?
Yeah, I have some thoughts on that. I think of all the information I hear today, this is my first starting point when I think about whether I want to apply for a PPP or not, because Jess covered the technical side of the equation. You can make arguments for and against, but I think there's another element that you, as the individual who's signing off on behalf of your leadership, needs to factor into that equation. And that is, beyond the technical test, is there a PR test at the end of the day? If you're an organization that Jeff's highlighted that has a lot of reserves and has possibly the ability to continue through this difficult period of time, and you apply, do you, what we call in Washington, D.C., want to eventually or possibly be put on the front page of the Post saying, here's organization X that applied and went ahead, and even though they had a year of liquid reserves or more, should they have been on that list at the end of the day? And so again, technically, you can certainly make a case, because if I go back to March of last year and I sit down and I say current economic uncertainty, yeah, there was a lot of strange things going on at that point in time. And so I think you can build defendable cases at that point in time. Conversely, I could see someone looking at the other side of the equation and say, why does this organization need money? And just as a last example, we've had organizations, and I'm talking specifically about groups that have a year's worth of liquidity, year's worth of expenditures in reserves. And we've had groups that have filed, have applied, they defended their case because of the current economic uncertainty. Conversely, we've had people on the other side of the equation who've gone ahead and said, look, we've got enough in reserves, we can make this happen. We're going to go ahead and pass on this as an organization and leave money for other organizations who may be more in need. So when you go through this PPP process, start at this first question and see where you and where your organization wants to go. If you want to proceed, continue listening on to all of this information at the end of the day. But a quick thought, Jeff.
Yeah, it's a great point. And when this started last year, the Trump administration was taking the position that they were not going to disclose the identity of PPP applicants and the loan amounts and whatnot. There were a number of Freedom of Information Act suits filed, including by the Washington Post and others, most of which were successful in getting a lot of that data released. In fact, another tranche of data was just released this week. And so essentially what you have to expect and presume now is that anyone who gets a loan and the loan amount, especially if it's for a larger loan amount, like over $150,000, it is likely going to be disclosed. So what we call the Washington Post test, you want to be in those articles, which I read all of the time about, they do the analysis of all the applicants, including nonprofits. There was one last year that was very critical of a lot of like wealthy private schools in the DC area that obtain loans and things like that, C3s. You want to keep that into account. I did a webinar last year with a group of CFOs from a lot of large 501c3 organizations. And some of them were saying, look, we just don't feel comfortable making the certification because we have so much money in reserves, even though we're taking a big hit because of the pandemic. But you got to make your own decision. But legally, just because you have reserves, I have seen nothing to suggest that you have to tap into those reserves before you make the certification. Moving on, second draw loans. 300 or fewer full and part-time employees. And then this second bullet point is the big difference. So first off, you look at the bottom, that necessity test still applies. So you got to make that same certification about the necessity test. But then there's an additional requirement, which is essentially that your revenue in 2020 has to have dropped by at least 25% compared to the same quarter in 2019. That's kind of the short way to explain it. Some of these calculations, as Mike knows, get extremely complicated. To keep this pretty simple, pick any quarter in 2020. You can pick any quarter. Did your revenues based on Form 990 calculations, or many of you haven't filed the 990 for 2020, but depending on your fiscal year, did your revenues go down by more than 25% in any of that same quarter? So calendar quarter 1, 2, 3, 4, compare it to calendar quarter, same calendar quarter in the prior year, did your revenues drop by more than 25%? If they did, then you meet this requirement. If they don't, then the only other way you can meet the requirement is to show that overall for the whole year 2020 compared to 2019, your revenues were down by over 25%. And then this talks about how you have to establish it. You have to provide to the bank financial statements or bank statements or like Form 990 returns to substantiate this. There are a lot of clients of ours that have looked at this and they said, we don't qualify. I mean, in some ways you could say, thankfully we don't qualify. We haven't lost that much, but there are quite a number of associations that, particularly in the year that they're booking their annual conference revenue, which is obviously a big revenue source for a lot of associations, where that quarter did show a very significant reduction. But it's going to vary. And then finally, if you have, and Mike, I'll let you comment on this, but if you want to, for loans of $150,000 or less, you don't actually have to provide the substantiation as part of the initial second draw loan application, but you do have to provide it later before you seek loan forgiveness. Anything to add on that?
Hop onto a quick question that just popped up, Mary Kate. I may have lost it. It relates to the question, can you apply for a second PPP draw relative to your first? Do you have that question in front of you that you can read to the audience?
Yes, I think the question was, could you possibly, if you're a C6 and you just got access, apply to the first draw, spend that money, apply to the second draw, and then maybe why it's more advantageous to do the first draw?
Well, first off, I don't see how it's even theoretically possible to do both in the same limited time period. You only have to March 31st to apply for the second draw loan. And as you see here, the second to last bullet point, the full amount of the first draw loan has to be spent on eligible expenses before you can qualify for a second draw loan. So I don't know how you apply first draw, get the loan, spend it all down, and then be able to do a second draw loan application within the relevant time period. So for C6s that have not applied before, I don't think you have any choice. You got to do a first draw loan. And secondly, I mean, there is the advantage, one of the biggest ones to the first draw loan, other than the bigger upper limit of $10 million, is that you don't have this 25% revenue reduction test. So you just have that necessity test. So it's theoretically an easier standard to meet. I have gotten the question, I think we got it in advance here, from some C3 organizations that applied for a first draw loan last year. They got it. They've spent it all in that, the relevant covered period from last year. They've applied for loan forgiveness, but the loan forgiveness application is still in process. We're finding some of these are taking quite some time. Can they apply for a second draw loan? I haven't seen anything to suggest that they couldn't. The only requirement I've seen is you have to have spent the first draw loan. I've seen nothing that said you have to have your loan forgiveness application approved first before you can apply for a second draw loan. Mike, you're nodding, assuming you agree with that. But I did hear from someone this week, I believe it was a client, that said they're in that situation. They went and applied for the second draw loan. And the bank, who was also the bank they used for the first draw loan, would not process it because the loan forgiveness application hadn't been approved. So this is another example where the law and the rules may be written a certain way, but how the banks actually apply it in practice may be different.
Yeah, and Jeff, just as a quick point of emphasis for the banks or the bankers that may be listening, there is confusion in the application. And in particular, the American Bankers Association has reached out to the SBA to clarify that. So the banks may be getting bad information that forgiveness needs to occur. However, the interim ruling for the second draw loan appears to allow borrowers to apply for a loan if they can certify that they have spent and intended to spend all first-time draws by the time they receive a second contribution. So there is clarification coming along those lines. It's just as you said earlier, when you have thousands of banks and organizations trying to administer a set of rules, there's going to be lack of clarity at times. But the rule of thumb is if you've spent it, you should be able to reapply if you're looking for the second draw.
Excellent. Okay. Not going to spend any real time on this except to note the first two bullet points. These are entities that are not eligible at all for second draw loans. Any business concern that is primarily engaged in political activities or lobbying activities. Again, if you are primarily, meaning more than 50% engaged, you shouldn't qualify for C6 status anyway. Including an entity that's organized for research or for engaging in advocacy in areas such as public policy or political strategy, or that describes itself as a think tank in any public documents. And so clearly you can see where the exclusion was focused here. And then secondly, there's this provision that's focused all on the People's Republic of China, but the way it's written, it seems to exclude any US entity, including a C6 organization that has a Chinese resident on its board of directors. And we actually have some clients that fit that bill. So something to keep in mind. There's some interesting questions, open questions about, could you have that individual, if it's just one person, resign prior to when you apply for the loan and whatnot. But I want to flag that for you in case that applies to your situation. Now, getting into my favorite part, the numbers. How do you calculate your loan amount? So C6 is, again, remember the maximum loan amount is the lesser of the below calculation or $10 million. It looks complicated. It's actually pretty simple, even for non-math people like me. First you take, but there's a few little wrinkles I want to point out. You take your aggregate total payroll costs, and again, payroll costs, remember everything, wages, benefits, employer paid payroll taxes, all of that good stuff. For all employees living in the US, that's a requirement, only for employees living in the US, for calendar year 2019, calendar year 2020, or the 1 year period before the date on which the loan application is filed. You select any one of those. So you're going to select the 1 year period that has the biggest number, right? Whenever you had the most. And for many of you, it might be 2019 if you had layoffs or whatnot in 2020. Then you subtract the amount of cash compensation, just cash compensation, not benefits, but cash compensation for any employee in excess of $100,000 a year. So for any of your employees that make more than $100,000, you kind of knock off the portion that's above $100,000. You can keep the $100,000 as part of the calculation, but you knock off the portion above it. So you get that number, divide it by 12 to get the monthly average, and then multiply that by 2.5%. That's how you get your average monthly payroll cost times 2.5%. That is your loan amount, the lesser of that or $10 million. The last bullet point just says that if you had an EIDL loan from last year, other than the up to $10,000 advance portion that you don't have to pay back, if you still have that outstanding, you can roll that and essentially refinance it into your PPP loan, and that can theoretically become forgivable. All right. Second draw loans, it's largely the same exact calculation, 2.5 times average monthly payroll cost, except there's an upper cap of $2 million instead of $10 million. That same period that you pick, which by the way is referred to as a reference period. So if you see that 2019 or 2020 or that 12-month period leading up to the loan application date, that's called the reference period. Same exclusion of salary over 100K and can only include employees living in the US. Now, eligible uses of funds. So this is if you want to have your loan fully forgiven, remember you have to spend minimum of 60% on payroll costs, which again, it's a very broad definition of wages, benefits, retirement plan contributions, employer paid payroll taxes, insurance premiums, etc. And then up to 40% on rent, covered mortgage interest, utilities. And then these last 4 bullet points, which are all new, these are expansions, and that's the same for first and second draw loans. These are expansions of those other eligible expenses beyond payroll costs that you can spend it on. The first 2 are COVID specific and a lot of the riots and other things that occurred last year. If you have covered worker protection and facility modification expenses relating to COVID, those are covered. Property damage costs related to vandalism or looting due to public disturbances in 2020 that were not covered by insurance, you can include those. And then these last 2 are very significant expansions of the covered expenses. One is expenditures to suppliers that are essential at the time of purchase to current operations. Again, very significant category that's going to apply to most associations. I had a question on a webinar yesterday about whether payments to vendors like consultants and whatnot would be considered suppliers that are essential at the time of purchase. I honestly don't know the answer to that. We don't have guidance on that. If you wanted to take a more conservative reading of suppliers, you might think only suppliers of product or whatnot, but I could certainly make an argument again that includes suppliers of services like consultants and whatnot if they're essential to your current operation. Granted, maybe that's not the best example because the consultant's probably not going to be essential to current operations, but there's lots of other examples of services that might be essential to current operations, outsourced accounting services, other things like that. I think you could make a good faith argument that those do apply to that definition. And then the last one, covered operating expenditures. It's not all operating expenditures, it's those that are listed here. Some of them are pretty specific, business software, cloud computing services, but product or service delivery, very broad. Processing, payment or tracking of payroll expenses, all human resources expenses, sales and billing functions, or accounting or tracking of supplies, inventory records, or expenses. So pretty significant expansion of what you can spend up to 40% of the funds on.
Hey, Jeff, let me chime in here real fast because there are 3 things that I think about from a perspective that are important. One was the necessity test. Two, just from the perspective that, if you go down this path, you need to look at this as almost like a bridge loan at the end of the day. Yeah, it's a forgivable feature, but basically the purpose of this is to get you from point A to point B in your organization. You've had tough economic times. You're in the process of figuring out how to change what the new business model is on a go forward basis. So it's a temporary solution, not a permanent solution. So this last bullet point that Jeff's brought to your attention is very important, because you're going to be experimenting, or you need to make improvements in how you're going to deliver membership value. And if you've got these covered operating expenses, for example, when you're talking about new business software, you may need a new AMS. You may need new financial reporting systems. You may need a new HR system. You may need cloud to improve security, to deliver product in a virtual environment at the end of the day. So, and as you get back into the office, when you look at PPE, those are costs that you're going to have to spend to make sure you've got a safe environment. So again, PPP, three things: look at the necessity, understand it as a bridge loan to your new operations on a go forward basis, and they've allowed you to spend money to go ahead and make that change. This is really important. Focus in on that. Jeff, I'm going to hop back to you, because I know we're at the 2:01 time frame.
Yep.
And I see the questions mounting.
Power through. I am almost at the end of PPP discussion. This is important, and this is, at least I read this, and Mike and I talked about it. He agrees, as far as we know, that this is an absolute prohibition on spending PPP loan funds for any of these things, not just in order to get forgiveness. So to contrast it, if you want to get total loan forgiveness, you got 60% on payroll, up to 40% of those other eligible expenses. And as I'll talk about later, there's a little safe harbor that's very helpful. But if you did spend some of it on other expenses and it went outside the safe harbor, you could still get the loan. It's not illegal, but it's just your forgiveness will be reduced proportionally. Here, it seems to be an absolute prohibition, and it's not surprising based on the concerns of those on the Hill about associations and lobbying activities, and not just associations, but for-profits as well. None of the proceeds can be used for lobbying activities as defined by the LDA, the Lobbying Disclosure Act of '95. Lobbying expenditures, really this means political campaign expenditures related to a state and local election. I think that was a misnomer. And then the third is expenditures. This is extremely broad. Expenditures designed to influence the enactment of legislation, appropriations, regulation, executive order proposed or pending before Congress or any state government, state legislature, or local legislature or legislative body. So it's pretty much all federal, state, and local legislative and administrative and regulatory lobbying. So it's a very broad definition, and it's broader than the definition in the lobbying tax law, which is what you use for tax purposes, Form 990 reporting purposes. It's broader than that, because that definition, except for that very narrow slice of very high level federal executive branch lobbying, does not cover most regulatory and administrative lobbying at the federal and state level. So for those of you that are in the business of doing a lot of that sort of lobbying, that many of you are, what you're going to have to do is make sure, even though your employee timesheets, and for those employees in your public policy or government affairs department are probably using the tax code definitions of lobbying for tracking their lobbying, this is much broader. And this does not just include payment to outside lobbyists, right? That would it is going to be easier to regulate. This is staff time as well. So you have to make sure that when you are applying the PPP loan proceeds to what you're going to spend on payroll costs, you have to exclude the amount of payroll costs spent by your staff on any of these things. And that's going to be a significant headache for some of your organizations that are heavily involved in public policy activities to make sure, for instance, if Mary Kate, heads ASE's public policy department, spends 50% of her time on lobbying as defined by this definition, then when you're going to apply the loan to payroll costs during the covered period, you cannot use 50% of her salary to be able to apply it to that. That's basically how it's going to work. It's going to be a bit of a pain in the neck, but it's going to be really important that you follow that. These things do get audited. We're seeing a lot of audits from SBA from round one last year. And this may well be the kind of thing that they focus on. So you want to be able to show that you have controls in place to show that you're not spending the PPP loan on these sorts of things. The loan terms, again, you choose a covered period, 100% guaranteed by the federal government. No collateral or personal guarantees are required. For any amount of the loan that's not forgiven, it's a 1% interest rate with a 5-year maturity period. Pretty favorable terms. Now, finally, this is the important part, loan forgiveness. We've already covered most of this. Essentially, to get loan forgiveness during that 8 to 24-week period, the covered period that you choose, you have to maintain employee and compensation levels, and you have to spend the money on the appropriate things. I'm not going to go over what those things are again. But this is what I want to focus on, the last 2 bullet points, these 2 safe harbors. So it says that from the SBA guidance, borrowers have to attempt to keep the same number of employees to the extent possible. But however, a reduction in over 25% of salary, so that's your total salary pool. If there's during the covered period, if there's a reduction of over 25%, then there's going to be a commensurate reduction, a proportional reduction in overall loan forgiveness. But if the reduction is less than 25% of total salaries, there will be no reduction in loan forgiveness. So they don't actually refer to that as a safe harbor, but I look at it as a safe harbor, and actually a pretty significant one. And then there's a second safe harbor that says if you cannot find employees to rehire, or if the entity is shut down due to COVID, the borrower will have a safe harbor and not be penalized for a reduction of headcount, not salaries, but headcount of greater than 25%. Then I'm not going to go over this, but basically, if you have a loan amount of $150,000 or less, you still have, for second draw loans, you'd have to still show that 25% a reduction before you apply for loan forgiveness. But in terms of otherwise showing, for everyone else, you have to show, the details about how you spent the money and whatnot on the right categories of expenses and everything else. But if you had less than $150,000, you just make these attestations here in your certification. You don't have to provide any documentation. You just have to hold on to it in the case you get audited later. This really doesn't apply to associations. Mike, did you want to say something on that?
Yeah, do you want to head back and go back and talk a little bit about reduction in gross receipts and the definition of gross receipts, because it is pretty important.
Yeah, and where is that?
What was the last bullet you were bringing up on the previous slide?
Oh yeah, here we go. My bad. Yeah, and so this is important because we've gotten this question. So what do we mean by gross receipts? And I think I have this on a subsequent slide, but Mike, why don't you speak to that? Because Mike's actually done a little drilling down on this and has a pretty good definition of gross receipts. You might think it's a simple term, but it's actually quite complicated, not just what categories of things are included in that, but how do you calculate it in terms of on an accounting basis? So Mike, why don't you speak to that for a minute?
Right, so we're at the 2:07 minute mark, so I'm going to go ahead and be real quick on this, but the bottom line, how you apply this test, it's going to be based upon your 990 reporting. And so if you're taking notes, it's pretty simple. You're going to go to page 9 of your 990, which is part 8, which is your statement of revenue. And you're going to go down to line 12A, which is your total revenue. And then you're going to add back various items that you incur for rental expenses, cost of goods sold, those types of things. You're going to come back to a gross number. All that math is pretty simple. Where I tend to see the error at the end of the day is that people are looking at their internal statements and they're not factoring in that when you report revenue on Form 990, you do not report unrealized gains and losses. Unrealized gains and losses are not, emphasis not, included in gross receipts when you go through that calculation. Some people, when they look at their internal statements, especially at the end of the second quarter of last year, were looking at huge market losses on their investments and figure they'd easily be able to pass through this part of the test. It's not the case. Look at total revenue, part 8 of your 990, and then realize that investment, unrealized gains and losses do not factor into that equation. I did that in 2 minutes, Jeff. It's more complicated than that, but we'll leave it at that.
Thank you. And we did get a question, Mike, that said for C3 organizations, if you got a loan last year and it was forgiven, we know that for for-profit taxable businesses, the forgiven amounts are not treated as taxable income, but it's still income. I am presuming that if for last year, if you had loan forgiven and you do have to book that as income, and that would be counted as gross receipts or not?
No, latest and greatest. Just got an update today on that. Those receipts are not included in the calculation.
Okay, excellent. Great to know. All right, real quickly, I'm really not going to focus on this because there were a number of C6s that applied for EIDL loans last year. They're not forgivable loans, but they are, you know, pretty good loan terms. And like I said earlier, other than this advance amount of up to $10,000, it's like a grant. The rest can be rolled in or refinanced with a PPP loan. But the reason I'm not going to focus on it much is there's these requirements now that you have to, in order to qualify, be located in a low income community and have suffered an economic loss greater than 30%. And I'm not sure to how many associations that's going to apply. So leave this here for your reference, but let me turn it over to Mike to briefly talk about something that is very important, the employee retention tax credit. Mike? Mike, you're on mute.
Thanks, Jeff. So if your head didn't explode with everything that Jeff's mentioned so far, it potentially could explode even further on this. So I'm going to keep this super simple because we want to get to some questions. But look at this as like a hidden gem. This is like an upgrade when you get on an airplane and all of a sudden you get upgraded. There's a possibility you go to a hotel. This is sneaky. It's a little bit of a sleeping beauty. Pay attention. You're going to have to do some modeling to figure out whether the ERTC, as it's sometimes referred to, or the ERC, may yield you better results than going down a PPP loan process. So in 4 minutes or less, understand in the second bullet point here that this credit specifically applies to employer paid payroll taxes, which is the 6.2% at the end of the day. Second, an important element on this slide relates to the fact that it is retroactive. Emphasis, retroactive, back to 2020. So if you did not apply for PPP in 20, you can go back and you can apply this. It also continues through June 30th of the current year. Last item, and the third most important element on this slide, relates to the fact that it is a refundable tax credit. So even if you didn't spend the amount of payroll tax that you're allowed to get under the credit, you get the credit and it's applied right to you. So for those at the end of the first quarter of 2021, you're going to make the adjustment on your payroll tax submission at that point in time, and you get instantaneous credit in 20 and 21, excuse me, in 21 for your first 2 quarters.
And I don't think you mentioned this, but this is a really important change. That last year, the rule was you could not simultaneously apply for a PPP loan and take advantage of the ERTC. That is changed. You can actually do both. And so while you, we'll talk about this, let me go to the next slide. While you can't use the same wages for both purposes, and this is where you get into the issue of kind of strategy about what covered period do you choose to try to make sure that you're not double dipping the wages. There is a potential, but here are the eligibility requirements. Mike, you want to talk about that for a second?
Real fast, there are one of 2 hurdles that you need to comply with. Jeff's got them lined up here for you. I'm not going to be able to explain fully and partially suspended operations. There are plenty of FAQs. We can get back to you with some later information on that. I think the applicability may be to an organization, Jeff, that has meetings, let's say monthly throughout the US, and they're at hotels or conference centers. And those were limited by government rule that you could not have X number of people participate. Absolutely. So you could fall into that possibility. If you don't like that hurdle, you can go to the second one, which deals with a decline in gross receipts. This gets pretty complex. I'm going to keep it very short given our time, but for 2020, you need to initially have a gross receipt reduction of 50% or more, and you continue on a quarter by quarter basis until you get above 80. For 2021, that 50% threshold has been reduced down to 20%. In other words, your operations in 2021 need to be 20% or more less than the prior year. Let's continue on, Jeff, because we are really short on time and we've got a bunch of.
And we'll keep this going a bit longer for those of you, if you can stay on to answer your questions. This is employer size. I don't think we need to really focus on that, but you want to talk about the percentage of wages, basically.
Yes, I do, because that's the point of this series of slides right here. And in essence, for 2020, you could get up to 50% of qualified wages. For 2021, it's 70%. So let's magnify that and put some numbers on it. Jeff, if you could go to the next slide, what you'll see is, So if I'm an organization and I want to go back to 2020, I'm allowed 50% up to the first $10,000 in qualified wages. So I can get $5,000 per employee in 2020. So if I have 30 employees and I go retro to 2020, I now have $150,000. Let's continue it forward in 2021. Now it's 70% of $10,000 in qualified wages per quarter. So I get 7,000 for the first quarter. I get 7,000 for the second quarter if I meet all the requirements. So I can be getting $14,000 per employee in 2021. So if I'm, again, a 30-person firm, 30 times 7,000 in the first quarter is 210,000. If I can meet it again in the second quarter, it's another 210,000. So now I've got 420,000 in 2021. I may have another 150,000 from 2020. So I could be up to 570 possibly. The point of the math here is to raise your eyebrows, and I come back to hidden gem. You can't double dip, and we've got that highlighted in the last bullet point, but you're going to have to do some modeling to figure out basically how do I get the most amount of money as quick as I can. It can be a combination of ERTC and PPP. You just can't double count and double dip on the wages at the end of the day. It's a sleeper item. Be aware of it. Talk to your outside consultants. They can guide you through this calculation. It's more there than you think at the end of the day. And Jeff, I think I did it in 4 minutes, so I'm going to stop.
You did great. And you can't double dip, but there, conceivably, there are some situations where it actually might be more financially beneficial to go with the ERTC for all the wages as opposed to applying for a PPP loan. Do not come to me for advice on that. Come to Mike or your accountants or others that can help figure out that math. But it's a very important consideration. And then finally,
and yeah. Jeff, back one slide real fast. So the minus on the ERTC, just in summary, is that it's relatively complex. The plus side are as follows. One, it's a refundable tax credit. It's money in your pocket right away. Two, you don't have to go through the application process. Three, you don't have to go through the forgiveness process. And four, it can be retro to 2020. So there are some advantages. Be aware of it. Point made. Microphone back to Jeff.
All right. Second to last slide. There were some beneficial increases to charitable deductibility rules to try to incentivize charitable giving last year. Those provisions, which are listed here, were all extended through 2021. I'm not going to get into those. You guys will all get a copy of the slides so you can see all this. And then finally, for those of you that have good eyesight like me or that don't have good eyesight, this is going to be really hard to read, but essentially I have here links. These are live links to all of the relevant SBA guidance that's been issued to date on all these different things, from the loan applications to the interim final rules, to the FAQs, to that one about association management companies, the EIDL loan application, and the underlying statute itself. So with that, that's the end of our formal presentation. Why don't I turn it back over to you, Mary Kate?
That sounds good. So the good news is you answered a ton of the questions that came up throughout your presentation, but we will try to get to one or two before we end. I know we're running long. Mike, there are some questions about how long it takes to get approval. I know this depends on your vendor, but how long until people are actually seeing money in the bank?
Great question. I will tell you this, more of the issue has been relative to the forgiveness process at the end of the day. That is taking much longer. I will tell you in the last 2 months of calendar year 2020, the actual number of signed off forgivenesses has increased exponentially. So that's good news on that side. On the front side, that can vary. It depends on, I will tell you the banks are working full time on this at the end of the day. So early bird gets the worm, get it in. Even candidly, I'm finding that some people aren't dotting I's and crossing T's, but the banks are guiding them through it. They're being good neighbors in our community and they're helping everyone. So get the process started. Be surprised you can get there faster than you think. If you're disorganized, it'll take longer than you think.
We just got a couple comments in the chat. It said one was C6 applied last week, got it a few days later. Second was, I guess, a C3 that had applied for a second draw loan, got it a few days later. These are very good signs. And I agree, that's what I've heard too, that the applications on the front end are getting approved quicker. The loan forgiveness applications from last year are taking a lot longer.
We have some questions about what happens if you apply, but then you need to lay off staff. And also, are there safe harbors for reduction in personnel?
Well, yeah, I mean, when I talk about that 25% safe harbor, that's kind of what that's all about. That, you can essentially during the covered period have your salary, I think it's based on salary, if I remember, right, Mike? If the total salary amount goes down by up to 25%, so 24% or something, you can still get maximum loan forgiveness. And if it goes over 25%, you can still get loan forgiveness, but it's going to be reduced proportionally.
Jeff,
Okay.
you're doing great with numbers. Good job.
We've also got a question about the covered period. Can this be the past?
No, the covered period is going forward. The reference period is the past, but that covered period for the period during which you're going to spend your PPP loan money, obviously you can't spend it retroactively. You got to spend it on the future. And the whole idea behind this program is that you're keeping your payroll at a certain level. That's why they call it the Paycheck Protection Program. So no, it's only a forward thing. And yes, to that question, that 25% reduction in the safe harbor is based on salary, not based on headcount. There's that second safe harbor for over 25% reduction. That is based on headcount.
Okay, and we've got some questions about the employee retention tax credit. We know it doesn't impact your ability to apply for the PPP, but you can't double dip on expenses. Do you have any more about if you cover wages with ERTC and some percentage, can you apply for another percentage for the PPP?
Absolutely. They can be done in conjunction, and hence the modeling that I was talking about. You're going to have to sit down and figure out, depending upon what period you want to look at, whether it makes more sense to apply wages from an ERT perspective, and which can apply from a PPP perspective. So there's going to be some serious math involved in that at the end of the day to figure out how to best position the organization for the most amount that you can make yourself available for.
Yeah, and to that end, some of those limitations on the PPP, like no compensation over 100,000, no compensation for time spent on lobbying by staff. Mike and I were talking about this earlier. We don't believe there's any, at least we haven't drilled down and seen any restriction that would make you not able to use the ERTC for those amounts. So those amounts that are carved out from the PPP loan, from the payroll cost amount, you should be able to use those for ERTC qualification purposes.
And can you retroactively apply for the ERTC in 2020?
Absolutely. That's one of the most beautiful things about it. So, yep.
Mike, there's a question here. Is the ERTC a tax credit used? Is the ERTC a tax credit used to offset payroll taxes rather than other types of taxes?
Right. So it's specific to payroll taxes. It's the 6.2% on Social Security tax at the end of the day. And here's the beauty of a refundable tax credit. So at the end of the day, the way this works, if your credit actually exceeds your payroll taxes that you're submitting, you get the full credit back. Let me say this one more time again. If you're paying payroll taxes of X, but you're eligible for a larger payroll tax credit, you get the full payroll tax credit. In other words, up to the $7,000 per person per quarter in 2021, or $5,000 per employee for all of 20. So that is big.
Mike, 2 follow-up questions that we got here on the ERC. What's the filing deadline for taking advantage of the ERTC?
So the 2021, the way you want to do it is, first of all, you got to reach out to all your payroll companies. I think I saw someone ask earlier in one of the Q&As, yes, your payroll company is aware of it. They're going to be working with you on it. So when you're filing basically your quarterly reports at the end of March and June of this year, that is when you will apply for the credit at that point in time, and you will get immediate relief because you will be paying less taxes. You will get that refund at that point in time. For 2020, it's a little bit different. You're going to have to file and I don't like to get too geeky and too nerdy here, but you're going to file what's called a 941X. So you're going to have to retroactively go back and amend each of your quarterly returns for the period in which you can apply for that credit at the end of the day.
Mike, another question. you can apply retroactively for an ERTC for 2020, even though you did not apply. Let me put it this way. Whether or not you got a PPP loan last year, you can still apply and utilize the ERTC retroactively for 2020, assuming you otherwise meet the requirements.
That is correct. Another one of the beauties.
Yeah. Okay, other questions, Mary Kate? We can go for another few minutes if you want to end at the bottom of the hour.
Yes, we've got one about let's see, if you work for the main organization, but your salary is reimbursed by the chapter, there are some issues about if the chapter can apply for a PPP loan separately.
So, I mean, again, part of this, we don't have definitive answers. And by the way, someone asked here, can an association managed by an AMC apply? You should go back and watch that portion of the recording on slide 9 to see that discussion. But that same discussion that I had there on slide 9 about AMCs, it's going to get into some of these other things as well, because there's a lot of complex arrangements in associations involving affiliated entities, sometimes chapters, but other entities as well, where there's a common paymaster. But people work for the foundation, the taxable sub, other things like that. And again, there is an argument that, could be made. And I got this a lot last year, because some of those other entities that don't actually have the people on the payroll may be the ones that suffer the biggest economic hardship. And so maybe the ones that qualify, for a PPP loan, whereas others don't. It's really hard to say. I mean, certainly the most conservative, safest approach is to say the only entity that can apply is the one that has the people on its payroll, period. But we just don't have a lot of definitive answers on that.
Some questions about IT contractors. I think that's the exact same answer there.
Yeah, but we did get a couple of these questions. It is clear that payroll costs, and there's an FAQ on this, do not include independent contractors. Do not. But what the FAQ also goes on to say, it says, however, independent contractors, if they're a small business, they can qualify on their own front. And actually, the PPP was written very specifically to include independent contractors, not just a typical established business.
Well, that sounds very helpful. If we did not answer your questions, submit it to publicpolicy@asaecenter.org, and we can help you out in our team. And now I'll hand the floor over to our CEO, Susan Robertson.
I'm simply going to thank our panelists. You have been amazing. What an incredible amount of information and great complexity, but your insights, I think, will help all of us. I've never seen so many questions on our Q&A and chat. Thank you all so much. 447 of you are still hanging in there, and I think that's a testament to the importance of the subject. So Jeff and Mike, thank you so much, and Mary Kate and Jeff, thank you as well. And we wish you a good afternoon, and we'll follow up with any remaining questions, as Mary Kate said. Thank you so much.
Thank you for having us.
Thank you.